to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English. On Thursday at 5:30 p.m. EST with attorney Chand Parvatnini, and on Friday with attorney Bhanu Babu Irindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com site has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today, we're continuing the topic from last week, which is the FAQs and adjustment of status outlook for 2023 Part 4. And we will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen to ask questions related to immigration and also ask for tips. Hi, Ms. Reddy. How are you doing?
I'm good. Thank you, Tony. I hope you're well.
Yeah, very well. Thank you. So, Ms. Reddy, do you want to get straight into the topic? Because we didn't get a chance on our last episode to, kind of finish the questions that were asked.
Correct. Yes. Please go ahead.
Right. So continuing from where we left off, another question for you is why must applicants request to transfer the underlying basis of their pending form I-485? And, why does USCIS not review its records and make the decision for the applicants?
Right. So that's a good question. And USCIS cannot do that because it's not always in the advantage of the applicant to transfer the underlying basis. Sometimes it's better that they don't, and there are many factors that play into it. So USCIS may not know all these factors and does not want to do something automatically, which would then, cause harm rather than help to the applicant. For example, if the applicant's child is aging out, USCIS is not going to make all those lengthy calculations and figure out, which I-140 is better to use. So if they had to do it automatically, they would just use the latest I-140, the one that has the best priority date, and that might cause the child to age out because the child's age was calculated based on the previous I-140, not the one that USCIS wants to use with the better priority date. So it's always better if the applicant requests for transfer of underlying basis, and of course it's within the discretion of USCIS to grant it or not, but the request has to always come in writing from the applicant. Also, another reason is say alien or a non-citizen has a pending 485 who does not have a visa number available based on that particular I-140, but they have an older approved I-140 in a different preference category. Say, it's an EB3, it's not current. They have an old one, 10 years old, EB2 I-140, which maybe is current. But USCIS cannot automatically use that old I-140, which is 10 years or more, old application, because the non-citizen may no longer have a relationship with that employer, with the employer that filed that I-140. Or the employer may no longer exist even. Maybe the company is closed. Or the employer may no longer be willing to employ that non-citizen. So it's always important that because of these reasons, both for the benefit of the alien as well as for the benefit of USCIS, that the non-citizen request the transfer of the underlying basis by filing a 485J. So, for example, in this case, if they have an old I-140 and that employer has not shut down and he's still willing to support the 485, they can send a 485J, and that's how USCIS knows, that the employer still exists. So, for these many reasons, it's always more prudent from USCIS point of view and also from the non-citizens point of view that the request come from the non-citizen and it come in writing.
Right. Right. So, Ms. Reddy, with that, we come to the next question about the non-citizens. I mean, why does USCIS not allow non-citizens to apply for adjustment of status based on the dates for filing chart every month of the year?
Right. So we know there are two charts, dates for filing and final action date. And USCIS is, whenever the visa bulletin comes out, USCIS sends a separate, posts a separate message whether they're going to allow, which dates that they're going to allow, whether it's by default final action dates, but if they allow the dates for filing, which are usually ahead of final action dates, so the date's always better for dates for filing. If they allow that table, they will usually let us know, let the public know by publishing it in their website. But it's, as I said, that's not the default. The default is final action date. And as the question suggests, they don't always allow the people to adjust based on the dates for filing chart. And the reason for this is that USCIS always, makes a determination of the availability of visa numbers. And if they think that that particular priority date visa number, even though not available for this month, might become available 6 months later or 2 months later or 3 months later, they take in cases in advance. That's what dates for filing 485 cases are. They expect that it'll become available soon. They want to be able to take these cases in and pre-process them so that by the time they complete the processing of the case, the dates will become final. And then they'll be able to actually process them because the dates for filing will then become final action date, and then they'll be able to issue the green card. So that is the purpose of, because USCIS takes 12 to 18 months to process cases, they usually allow that period of time and also figure out what the availability is, after the processing time, and that's how they figure out the dates for filing. And that's why not always are dates for filing used. It's only used when they think that they might have enough dates in the future and they have a lengthy processing time, and the two fit in together.
Right. So, and when does this special exception to the per country levels for the employment-based categories apply, Ms. Reddy?
So the per country levels is basically what it is that every country, they have a limited number of green card numbers, say 150,000 or 250,000 or whatever the number is for that particular year. Out of that, 7% of the numbers go to each country. So India gets 7%, Iceland gets 7%. So no matter what the number of the population of that country is, they all get 7%. Each one gets 7%. And that is the rule, the statutory rule as to how many, what percentage of visas every country can get. But when the countries have gotten that 7% and they don't need it and the numbers are not being used, then the 7% doesn't apply. And during those times, like we've seen this year and last year and the year before, India and China have gotten much more than 7% of the total number of visas. They've received 240,000 visa numbers this year and last year. So they've received a lot more than they should have received, and it's not a lot more than 7%. So when there is extra visa numbers available and nobody needs them, then that 7% per country level rule that doesn't apply. And then the country that needs them the most, or which is the most backlogged, which is basically India and China, because all the other countries
not as highly populated as ours.
Exactly, and not that much. They don't want to come to the US as much as we do.
Yeah.
And so India usually gets that benefit because India is highly backlogged with employment-based cases.
Right. So with that, Ms. Reddy, we go to the next question, and that is when USCIS adjudicates a principal applicant's adjustment of status application, does USCIS also adjudicate the adjustment of status applications of the dependent family members? And what if the dependent family members are not approved before the priority dates move back?
Right. So usually if you have a family, immediate family, that is the spouse and children, USCIS, you can file the 485s together. And USCIS makes every effort to adjudicate the principal and the derivative family members at the same time. But it's not always possible. If, for example, a derivative family member is approvable, they might approve that visa, but they might not approve the one for the principal. So it happens. Sometimes the derivative gets approved first, and sometimes the principal gets approved, but the derivative case gets stuck. It could be just because they have separated the cases when they shouldn't, and so they're not being approved at the same time. Or sometimes maybe there's an issue in the one of the cases. Maybe there is a request for further evidence issued, and there was some document missing, and they couldn't approve all the cases at the same time. So what unfortunately happens is if say the principal applicant's case gets approved, but the wife could not get approved, say by the end of this, right, by the end of last month, it couldn't get approved. And then as we saw this month, the visa numbers moved back or retrogressed, then that wife's case is pretty much stuck until the visa numbers become available again. Only then, they will process the case and keep it ready, but they will only be able to allocate a visa number and complete adjudication once visa numbers become available again, and the priority date becomes current as per the visa bulletin.
Right. So there's not much that a dependent can probably do in this particular case.
No, they just have to watch and wait, and it's unfortunate that what happens in this case is also, I wanted to point out a few difficulties here. Because if the principal's case gets approved, say the principal was on a H1 and the spouse was on a H4, and they're wanting to maintain their non-immigrant status because, say, the spouse has a H4 EAD, whatever reason, they don't want to use their EAD from their 485. Now, if the principal's 485 gets approved, the person now becomes a green card holder, a permanent resident, no longer a H1. So the spouse is no longer on a H4 and cannot then use the H4 EAD. So will now be only on a status, pending status, adjustment of status, 485 pending status. So they will not be able to use that H4 EAD, but they have to apply for a separate EAD under their 485 status if they have not done that before. So there are a lot of problems that happen if all the family members don't get approved at the same time.
Right. Understood. So, Ms. Reddy, what about, what happens when an EB3 I-140 downgraded petition is pending and attached to a still pending form I-485? Is it true that the EB3 I-140 does not have to be approved to allow a transfer of underlying basis of the form I-485 to an approved EB2 I-140 where the EB2 priority date is current under the final action dates? The question itself is very, very confusing. Could you please break it down and explain it to us?
I will. I'll explain the question. Basically, what's happening here is the person has an I-140 which is pending, EB3. And so they filed the 485 and the I-140 together. I-140 is not yet approved. 485 is also still pending. Now, they also have an EB2. And the EB2 priority dates moved up like they did, right? We've seen that last year, all the EB2s moved up. So now they want to upgrade their petition, from the pending EB3 to the already approved EB2, which they had already with them. So now the question is, if that EB3, which they filed along the 480 with the 485, if that is still pending, can you move from that pending I-140 to the approved I-140? That is the question, basically. So
Wow.
the answer is yes, you can. It doesn't, the I-140 upon which the 485 was based doesn't have to be approved to be able to transfer to another I-140. So there are many scenarios here which you can use for transferring. The transferring can take place between one pending I-140 to another pending I-140 also. Say the EB2 I-140 is also pending. It's possible to transfer. Say you have an EB3 and you do not have an EB2. It's possible to transfer and apply for an EB2 at the same time. So you can apply for a new EB2 I-140 if you're eligible based on your labor certification. And you can also request for transfer of underlying basis. So there are many scenarios. Also, say you have a family-based petition that was filed and the priority date of that is better. You can ask for the priority date to be transferred or the I-140, I-130 to be approved. The priority date of so the pending 485 to be transferred to the I-130 instead of having it based on I-140, which is employment based. So there's so many cases in which the immigrant petition, which could be an I-130, I-140, whatever it might be, can be transferred to your existing 485 application. So those are the scenarios and many more which we haven't even covered.
Right.
Lots of
Right. So,
flexibility there.
right, yeah. So since we're talking about I-485s and I-140s and the adjustment of status and all of that, what are the kind of RFEs we're looking at regarding these things right now, Ms. Reddy?
So for the 485s, most of the time the RFEs that we're seeing now are RFEs for medicals, maybe RFEs for birth certificates, because it could be that the birth certificate either was not provided or the birth certificate was registered late and they're asking us for secondary evidence that has to be dated from close to the date of birth. So secondary evidence, they ask for affidavits. There's one thing is they ask for affidavits from the parents, which can be dated currently. The other thing they ask for is secondary evidence such as school leaving certificate, the date of birth on that. They ask for hospital records, which were obtained at the time of birth. So this is secondary evidence that they ask for usually when the birth certificate is either not available or the birth certificate is registered late. And sometimes maybe there's a problem with the birth certificate. It doesn't have a name on it. Also, it could be that there's no birth certificate. We already submitted secondary evidence. Then they will ask, if you're from India, they will ask for a non-availability certificate. So these are all the RFEs centered around specifically a birth certificate, and it's quite common to get these RFEs. As I said, the other common thing is asking for medicals again, because they need new medicals with COVID-19 vaccination requirement. After that, there was a new requirement, so they need new medicals with the vaccination requirements, which was not done in 2020 because vaccines were not available then. Also, there could be documents asking for status of the person. As of the date of filing, what was the status? Maybe we didn't, you didn't submit an I-94 to show what your status was. Maybe there are other questions about status that they dig out and, they're trying to find out, okay, so it looks like your I-94 is expired, you've provided it. Did you update the I-94? If you didn't, then do you fall under one of the exceptions under which you may, file the 485? You have to always be in status when you file. So status is another big question that they always look into and ask for documentation about.
Right. Right. Ms. Reddy, also one common question that we get regarding the I-485, I'm sure you're tired of answering this, is if they can leave their sponsoring employee after they file for the I-485 and what the process is regarding that. People have a lot of apprehensions regarding this. If you could please clear the air for us.
Yes, absolutely, Tony. And, we always have different listeners and different watchers,
tuning in always,
spectators
right?
watching. So it's always good to sometimes repeat these commonly asked questions. So AC21 is the process by which you can change employers. Now, changing employers. Yeah. So changing employers is basically what needs to be done is that there are two requirements that need to be met. One is that the I-485 should be at least 6 months old, should have been filed at least 6 months ago. And the second one is that the I-140 should have been approved, actually 3. And the third one is the new job should be the same or similar to the old job. So if these 3 requirements are met, then they can transfer their underlying 485 to another employer by filing what is called a 485J application.
Right. And what is the processing time for the I-485, considering the refiling and the resubmissions and the RFAs and all of that?
So usually USCIS says that it takes 12 to 18 months, but it's also recently been taking 24 months. So the processing times are a little confusing right now, because those cases that were filed in 2020, they were not processed. Some cases were processed recently, so 2 years. It took them 2 years to process those cases because they got a sudden overload of thousands of cases within a period of 1 month in October 2020. But generally, cases that were filed after that got processed faster because they were not stuck in that service center which was backlogged. It really depends on which service center, because again, every service center has a different processing time. So Texas Service Center was the most backlogged because most of the cases went there. Then they moved all those cases to NBC, the National Benefits Center, and then again to the field offices, and their cases started getting processed faster. But in general, about 12 to 18 months is what USCIS takes to process 485 cases.
Right. Also, Ms. Reddy, since we're talking about the current situation now that we are, post the pandemic, we obviously know that it was not all rosy and everybody had to get back on their feet, and it took us a little time, including the US consulates and the USCIS. So now that more consulates are opening up, now that more visa slots are filling up, now that we have a lot of slots opened as well, do you think that I'd like to rephrase that, is there a change in the number of visa slots being filled or the visas being approved? Not just H1Bs, F1s, B1s, B2s. How's it about there? I know the most priority is being given to the H1Bs and the F1s and all of that. But what's happening with the B1s and the B2s?
Right.
Is it getting better, Ms. Reddy? Can we visit?
Right. So yeah, the priority for visitors visa is the least. And they're giving, as you said, rightly said, there is more priority for the students and for the H's. Even those are really backlogged. There's no visa dates available for 6 months at a time. People are, of course, using other means of getting visa dates, using brokers, etc. And I think they put a stop to that also. But
Desperate times and desperate measures.
Definitely, exactly. I am not making any comment about that because I understand. But of course, there are always people who take advantage of that. We're not talking about people who make use of it, but the people who are taking advantage of the situation. But with reference to your question, whether B2 visas will become easier, they will. And to tell you the truth, every other government organization, every private organization has basically come, it's business as usual. In most organizations, I don't know why the Department of State is still using COVID as an excuse to delay processing cases. It doesn't make any sense to me. Yes, they have a backlog, but they should be able to clear that backlog, and provide the required services. So I feel it's also maybe partially political, partially, it could be many reasons why they're not doing it. But I'm hoping very soon the good thing is that there's Dropbox facilities, so not everyone needs to go for a visa. There's visa waivers for people who are filing extensions, so they don't have to go for interviews again. In that scenario, it might be much faster for them to get visas. But yeah, there is a delay. But that's worked to our advantage, and not so much depending on who the person is.
Right. And on that, I think that was a very interesting approach towards this. It was very, oh, I thought that was an interesting approach. So with that, unfortunately, again, we've come to the end of the session, and we shall come back with a new topic again on the next session. And like always, also discuss points for our new listeners, continue some things for our new listeners every time, new viewers. I mean, and like I always say, it's a privilege hosting you, Miss Reddy. Thank you so much.
Thank you, Thorni. Take care.
You're watching Sakshi Live. This is Torani. Thank you.